Was the Occupational Safety and Health Administration properly created? Was the grant of authority Congress gave the agency constitutional and valid? Or did Congress create an overpowered agency to micromanage businesses throughout the United States? That's the question in the case Allstates Refractory Contractors, LLC versus Julie L. Sue, Acting Secretary of Labor et al. Sadly, the Supreme Court decided not to hear the case, even if Justice Gorsuch would have and Justice Thomas wrote a dissent. So we'll look at this case next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach rights and generation be free. And I'm glad you could join me today. I almost passed over this case because the court didn't hear it. But when I looked at Thomas's dissent, I found some very interesting information. I coupled that with some research I did when I was writing my book and turned it into this article. I'll talk more about the website and other things at the end of the episode. For now, let's take a look at this Allstates Refractory case. When I was researching my book, The Constitution Study, I made a shocking discovery. There are 537 departments and agencies in the federal government, yet only 49 of those agencies exercise powers delegated to the United States by the Constitution. Now, this case asks a similar question about the Occupational Safety and Health Administration, or OSHA. Congress gave the Occupational Safety and Health Administration the power to enact and enforce any workplace safety standard that it deems reasonably necessary or appropriate. This petition asks us to consider whether that grant of authority is an unconstitutional delegation of legislative power. The petition in question is for a writ of certiorari, asking the Supreme Court to review this case. Sadly, at least to my mind, the court has declined to hear the case, a decision with which Justices Gorsuch and Thomas disagreed. Justice Thomas went so far as to write a dissent from the decision. The Thomas dissent listed two subsections of Chapter 15 of Title 29 of the United States Code, which covers occupational health and safety. The first of them, subsection 652 sub 8, defines the term occupational safety. The term occupational safety and health standard means a standard which requires conditions or the adoption or use of one or more practices, means, methods, operations, or processes reasonably necessary or appropriate to provide safe or healthful employment and places of employment. The second establishes the procedures for the creation and management of the occupational safety and health standards. The Secretary may by rule promulgate, modify, or revoke any occupational safety or health standard in the following manner. Under subsection 2, the Secretary shall publish a proposed rule promulgating, modifying, or revoking an occupational safety or health standard in the Federal Register and shall afford interested persons a period of 30 days after publication to submit written data or comments. While the court was asked to determine the question of delegation of powers, there is a more fundamental problem with Chapter 15 as a whole. The Congress finds that personal injuries and illness arising out of work conditions impose a substantial burden upon and a hindrance to interstate commerce in terms of lost production, wage loss, medical expenses, and disability compensation payments. The Congress declares it to be its purpose and policy through the exercise of its powers to regulate commerce among the several states and with foreign nations, and to provide for the general welfare, to assure so far as possible every working man and woman in the nation safe and healthful working conditions, and to preserve our human resources. While Congress may be correct that work-related personal injuries and illnesses places a burden on interstate Congress is not authorized to regulate said work-related situations. Only interstate commerce itself. From Article 1, Section 8, Clause 3 of the Constitution, we read, Congress has the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. You see, Congress can regulate commerce among the several states, but not anything that impacts said commerce. Furthermore, Congress claims to create these laws under the power to provide for the general welfare. but Congress has not delegated the power to provide for the general welfare as they claim. Read the General Welfare Clause, Article 1, Section 8, Clause 1. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises, to pay the debts, and provide for the common defense and general welfare of the United States. Congress has the power to lay and collect taxes, to pay the debts, and provide for the common defense and general welfare of the United States. Capital U, capital S, a proper noun. The very same proper noun the 10th Amendment uses to say, the powers not delegated to the United States by the Constitution, nor prohibited by to the states, are reserved to the states respectively or to the people. Congress has not delegated the power to regulate labor. Neither is it delegated the power to regulate anything it thinks is for the general welfare. During a debate on bounties for cod fishermen, none other than James Madison said on the floor of the House of Representatives, if Congress can apply money indefinitely to the general welfare and are the sole and supreme judges of the general welfare, they may take the care of religion into their own hands. They may establish teachers in every state, county, and parish and pay them out of the public treasury. They may take into their own hands the education of children, establishing in like manner schools throughout the Union. They may assume the provision of the poor. They may undertake the regulation of all roads other than post roads. In short, everything from the highest object of state legislation down to the most minute object of police would be thrown under the power of Congress, for every object I have mentioned would admit the application of money and might be called, if Congress pleased, provisions for the general welfare. The General Welfare Clause was never meant as a catch-all power for Congress to do whatever it thought was for the general welfare of those in the nation. Rather, it seems quite obvious that by its placement in a taxing clause, that the General Welfare Clause was meant to allow Congress to collect taxes to pay for the ancillary costs of its duties, such as paying the salaries of those offices created by the Constitution, maintaining other needful buildings, and providing necessary supplies. Based on this, Chapter 15 of Title 29 of the United States Code was made contrary to the Constitution of the United States. Therefore, as Alexander Hamilton stated in Federalist Papers number 78, no legislative act, therefore, contrary to the Constitution, can be valid. To deny this would be to affirm that the deputy is greater than his principal, that the servant is above his master, that the representatives of the people are superior to the people themselves, that men acting by virtue of powers may do not only what their powers do not authorize, but what they forbid. As I said, this case is not about the creation of OSHA, but of the powers Congress delegated to it. The Constitution vests all legislative power herein granted in a Congress of the United States, Article 1, Section 1 of the Constitution. And we have held that the Constitution categorically forbids Congress to delegate its legislative power to any other body, including to an administrative agency. All legislative power, all power to make law, is vested solely in Congress. And the Constitution does not delegate that body the power to delegate the powers vested in it. However, the courts don't seem to get tripped up on this particular detail. But under our precedent, a delegation of authority is constitutional so long as a relevant statute sets out an intelligible principle to guide the agency's exercise of authority. If, as the court has held, the Constitution categorically forbids Congress to delegate its legislative power to another body, how can they say that the delegation of authority is constitutional under any circumstance? The answer is by violating their oath of office and placing precedent and politics above the supreme law of the land. The Court of Appeals for the Sixth Circuit upheld the delegation of authority to the Occupational Safety and Health Administration under this intelligible principle test over Judge Nalbandian's dissent. Based on this unconstitutional intelligible principle test, the courts, including the Sixth Circuit Court of Appeals, have set aside the Constitution in support of a political agenda, namely empowering unelected bureaucrats to effectively make law. Since these unconstitutional laws include the collection of fines, fees, and other pseudo-taxes, Congress's dereliction of duty is the very definition of taxation without representation, or as the Declaration of Independence put it, for imposing taxes on us without our consent. The American people's consent, as shown in the Constitution, did not include allowing unelected bureaucrats to impose fees, fines, or any other form of taxation. Since the courts are not delegated the power to simply make up the rules as they go along, Justice Thomas states, I continue to adhere to my view that the intelligible principle test does not adequately enforce the Constitution's allocation of legislative power. Justice Thomas is correct. Since the Constitution categorically prohibits Congress from delegating their legislative power to another branch, these laws are unconstitutional and void. This case is the perfect example, not only of Congress creating the bloated administrative state, but also of the courts placing the imprimatur of legitimacy on their actions. From Thomas's dissent. This case exemplifies the problem. Congress purported to empower an administrative agency to impose whatever workplace-related safety standard it deems appropriate. That power extends to virtually every business in the United States. Congress literally handed over the keys of the regulatory system over to OSHA by allowing them to create any standard they deem appropriate with little if any oversight, review, and certainly no due process. The agency claims authority to regulate everything from a power lawnmower's design to the level of contact between trainers and whales at SeaWorld. Not only does OSHA claim the authority to regulate every aspect of the workplace, but to overrule the Constitution itself. Specifically, Title 29, Section 1903.3 of the Federal Code of Regulations claims compliance, safety, and health officers of the Department of Labor are authorized to enter without delay and at reasonable times any factory, plant, establishment, construction site, or other area, workplace, or environment where work is performed by an employee of an employer. Anyone heard of the Fourth Amendment, which reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated"? Who cares if a search of someone's business is reasonable or not, or if there's probable cause or even due process? This group of unelected bureaucrats claim that the Constitution does not apply to them. And if you refuse to allow them to illegally search your business, guess who gets to review the refusal? Upon a refusal to permit the compliance, safety, and health officer, in exercise of his official duties, to enter without delay, the compliance, safety, and health officer shall endeavor to ascertain the reason for such refusal and shall immediately report the refusal and the reason therefor to the area director. The area director shall consult with a regional solicitor who shall take appropriate action, including compulsory process if necessary. That's right. The very same agency attempting to illegally inspect your business reviews your objection to it. Please notice, none of these powers are recorded in the laws of the United States because they are not law. They are merely regulations impersonating laws and used to destroy your rights. The Occupational Safety and Health Act may be the broadest delegation of power to an administrative agency found in the United States Code. If this far-reaching grant of authority does not impermissibly confer legislative power to an agency, it is hard to imagine what would. Thomas is correct. If OSHA isn't the greatest abuse of power both by Congress in creating it and in the agency by how they wield said power, I don't know what is. I can think of no other act by Congress that so exemplifies the 10th grievance listed in the Declaration of Independence. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. Just imagine if other agencies had similar discretion. It would be no less objectionable if Congress gave the Internal Revenue Service authority to impose any tax on a particular person that it deemed appropriate, and I doubt any jurist would sustain such a delegation. Again, Justice Thomas is correct. Yes, as inconceivable as this law is, the 9 justices on the Supreme Court could not muster the 4 votes needed to even hear the case. That, ladies and gentlemen, is not only inconceivable to me, but apparent dereliction of their duty of the highest order. The question whether the Occupational Health and Safety Administration's broad authority is consistent with our constitutional structure is undeniably important. At least 5 justices have already expressed an interest in reconsidering this court's approach to Congress's delegation of legislative power. Because this petition is an excellent vehicle to do exactly that, I would grant review. Justice Thomas then listed 2 cases, Paul v. United States and Gundy, where Justices Kavanaugh, Alito, Gorsuch, Roberts, and yes, Thomas himself, have questioned Congress's delegation of legislative power. So why couldn't this case get the 4 votes necessary to review? We may never know. Here, the Supreme Court had an excellent opportunity to fix the mistake of the intelligible principle test, yet it didn't even take a swing at the case. As I said, we may never know why. I suppose the most generous view would be that there are more important cases to deal with this term, but I don't see that. Which leaves me with what I believe is the more likely reasons. Either it was politics or the desire to maintain the unconstitutional administrative state, neither of which are good for the Republic. As Justice Thomas said, because the standard this court currently applies to determine whether Congress has impermissibly delegated legislative power largely abdicates our duty to enforce that prohibition, I would grant the petition. Which is why it is so important that we, the people, read and study the Constitution. Not only so we are prepared to defend and assert our rights from the abusive powers of the bureaucrats, but so we can hire representatives at the state, federal, and yes, even local level to help us protect ourselves and our rights. Because as long as unelected bureaucrats have the power to make the rules, we are not a republic, and we are most definitely not free. OSHA, a most obvious agency of evil and villainy. You must be careful, because this agency is literally taken over our workplace. They've thrown out the Constitution, placed themselves above the rule of law, and make us all pay for the privilege. Now, I've had my issues with OSHA for many, many years, but I thought this case, Thomas was right. This was an excellent case to look at the problem, and they whiffed. They couldn't even be bothered. I hope one day we find out why, because the answers I come up with are not very good. All the more reason why we need to learn to defend and assert our rights for ourselves. If you're expecting the courts to do it, they will disappoint you. If you're expecting Congress to do it, they will disappoint you. If you're expecting the administrative state to do it, no chance, none in hell. It's why we need to read and study the Constitution for ourselves. It's why I wrote my book, The Constitution Study, to help people understand the Constitution in plain conversational English to protect themselves from these bureaucrats. And by the way, the others in government that want to take away your rights. It's why I recommend this new course I found called The Miracle of America, which talks about our history, not just the Constitution, but the foundations for it as well. Oh, and since you follow us here at the Constitution Study, you get an entire list free. Just go to constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide to get your lesson absolutely free. Sign up for nothing, take the lesson. If you like the course, you want to take the rest of it, it's just $17.76, not a wallet buster. Again, find out more, go to constitutionstudy.com/1776 study guide. And by the way, if you're going to do this on your phone, may I suggest Patriot Mobile, America's only conservative Christian wireless provider, the only one we got. They don't attack our rights, they support our rights. They support organizations that are helping to protect your constitutionally guaranteed rights, including the Constitution Study. Just go to patriotmobile.com/constitution and find a plan that works for you. You'll get great 4G and 5G coverage using the same networks and towers that the major carriers do. Best of all, if you use the code Constitution at checkout, you'll get activation absolutely free. So again, go to patriotmobile.com/constitution to find a plan and use the code Constitution at checkout to get free activation. Most of all, I'd just love it if you shared this material. I was talking earlier today to a group in my local county, and they were shocked by what they learned in just 10 minutes of me talking to them. That, ladies and gentlemen, is something worth sharing. This is the end of September. Constitution Month is over, but your opportunity to both learn and to share is still there. Knowledge is not power until put into action. You can put it into action by protecting your rights and by sharing it so others can as well. That, ladies and gentlemen, is the true corrective of constitutional abuses. Thomas Jefferson said it. Education. And you can share it. And I hope you come back and join us, and hey, maybe bring a couple of friends the next time we meet here at the Constitution Study.
Love your neighbors and have a few good friends every day.